Good morning, everybody. Apologies for starting a couple of minutes late. We just saw that there were lots of people still joining and we wanted them an opportunity to join the webinar. Thank you very much for everybody who has made the time to join us this morning. It's very nice to see so many familiar names amongst the participants. First and foremost, I would like to welcome our three contributors this morning. All three of them are well-known, well-respected, busy professional people. So we are really happy and very thankful that they've made the time to share their expertise with us this morning. So we have a panel of three with us. We have Professor Johann Kirsten. I don't think he needs any introduction. I think you probably all know him. He's with the Bureau for Economic
Research.
Research. And he's been involved in the land debate, I think, longer than I have, which is some 26 years. So thank you very much.
Good morning. Thank you.
We also have Advocate de Waal, who is a senior advocate at the Cape Bar. Now, you might know senior advocates are incredibly busy people, and we're very privileged to have him this morning. He will be speaking to us about the legal framework of this whole custodianship thing. So we're very happy that he's also joining us. And then we have Prof Vivian, from Wits University, who is also on the board of the Free Market Foundation. And the foundation has been doing a lot of work and has also been very vocal around the protection of property rights and the whole amendment of Section 25. So also very happy to have him with us this morning. So the way that we're going to run the program this morning is I'm going to give a brief introduction, sort of a background just to position this whole debate. Then I will be handing over to Prof Kirsten. After him, Advocate de Waal will talk to you, and then we will have Prof Vivian lastly, and then if we still have time, I will ask them a few questions. We probably won't have a lot of time for questions, but we will do that if there's sufficient time. So just by way of introduction, this constitutional review process effectively started in February 2018. That was when the EFF proposed a motion in Parliament for Section 25 of the Constitution to be amended to provide for expropriation without compensation. Now, incidentally, this was the second time that the EFF had brought such a motion. The first time around, there was no support for it from any of the other parties. The second time round, they did manage to get support, but the ANC substantially amended the motion that the EFF had proposed. So the EFF motion, the original one, requested Parliament to establish an ad hoc committee to review and amend Section 25 to make it possible for the state to expropriate land in the public interest without compensation, and to conduct public hearings to get the view of ordinary South Africans, policymakers, civil society, and academics about the necessity of and the mechanisms for expropriating land without compensation. There was also a B part to the original motion that the EFF proposed, and that was that the necessary constitutional amendments be made with regards to the kind of future land tenure regime needed, taking into account the necessity of the state being the custodian of all South African land. So from the outset, the EFF did actually ask for an amendment that would allow for state custodianship. But in the amended motion, that was the amendments basically were proposed by the ANC, and that was the one that it was accepted, there was no reference to state custodianship. So then we had a long process in which many of you participated, and 3.5 years later now, and a number of processes and public hearings later, this ad hoc committee had now finally adopted a bill in September of this year, so very recently. That bill will now be debated and voted on in the National Assembly, and this will probably only happen after the November local government elections. The bill is basically an ANC bill. It was the wording that was proposed by the ANC. It was voted on by ANC members only. But interestingly, at this very, very late stage of this 3.5-year process, the ANC has now included state custodianship, and they've qualified it to state custodianship of certain land. Despite the fact that they have now included that, which is something that the EFF had wanted, the EFF had stated very clearly that they will not support this bill. They actually, the ANC representative in the committee called it a sellout bill. So we all know that the ANC needs the EFF vote for, to vote with them to get this bill through Parliament. So we don't know what's going to happen. At this stage, it seems as if they might not get the necessary majority, but this is politics, so nobody can predict what can still happen. So the structure of the bill is basically, in layman's terms, the following. Government is mandated to pass legislation that will provide for circumstances where zero or no compensation will be payable. The courts will not have much discretion in these circumstances for awarding anything but no compensation, because the bill has now been amended in such a way that it basically says that the legislation will determine in which cases no compensation is payable. And that is quite worrying. Then the state can also pass legislation that will place certain land, which can, for example, be farming land, under state custodianship. This will limit the landowner in how he or she will be able to use the land, and will give far-reaching powers to the state to regulate what happens on that land through a system of licenses and permits. And in all likelihood, no compensation will be paid to the landowner for the loss that they will suffer as a result of the ownership being curtailed in this manner. Government will not be the outright owner of the land, but will in effect control what happens on the land, and may even grant use rights to third parties. So there's a lot of unanswered questions regarding this whole thing of state custodianship. It's quite murky. And I think the kind of questions that arise that we would like to try and address today, although we don't promise you that we have all the answers, are things like, what is state custodianship? What does it mean? Do we have examples of state custodianship in our law? Will state custodianship solve the land question? Does it address the real issues as identified in many reports, for example, the high-level panel report? What are the likely impacts on the sector and on the economy? And is it permissible to include state custodianship in our property clause? So we are going to ask our three experts then to deal with this from different perspectives. So first of all, we will then have Prof Kirsten, who, as I said, has been involved in the land debate for a very long time and has written extensively, also recently co-written an article on state custodianship with Wandile Shlobo and Theo Bosso from AgriSA. Sorry. So Prof Kirsten, over to you.
Thank you, Annelies, and thank you for the opportunity. You've started your introduction with the process of referring to the motion brought by the EFF, but we probably need to take a step back and remind ourselves that it was all part of a suicide pass that the new president of the ANC received in December 2017, where the RET faction of the ANC proposed the resolution to do expropriation without compensation and ask for the amendment of the constitution. So technically the ANC was in a corner, and the EFF obviously saw that and then put forward that motion to make sure that it happens. But if we think about the motivation behind it, and you've already said this, that we all know that land reform progress is not really related to what has happened in terms of what the constitution says. There are many other factors. So my argument really is that the motivation for this amendment has very little rationale from an economic, social justice or equity perspective. And sometimes the argument is presented that the reason or the need for the motion or the need for the amendment is to deal with the slow pace of land reform, and that we should actually change the constitution because that will advance the pace of land reform. So this is, in short words, false. So I will just briefly want to say why this is false. Firstly, we need to think about the statistics on land reform that is often misquoted, because only a half of the picture is provided, and sometimes I think even the statistics are incomplete. So if you really start to unpack the progress, and I've got updated figures up to August 2021, based to a large extent from Johan Bormann, which is also involved with AgriSA on the monitoring of land reform statistics. The redistribution program so the elements of the new statistics is redistribution by the state through the various state programs, from the LRAD program, etc. The restitution claims, the plus dimension of land reform where the state acquires land from individuals, the private acquisition by Black individuals or people of color from white farmers, land that is acquired by the state for non-agricultural purposes, and then also financial compensation where land is claimed, but the claimants don't receive the land itself. The land remains in the ownership of the existing owner, and the rest is then paid to the community or the claimants in cash. So that's an option that they do. If we then translate all of these in hectares, we basically get to 16 million hectares, or roughly 69% of the 30% target that we've put forward in the NDP, which is 23 million hectares. So 16 million hectares already transferred, or land rights have been restored in the context of a target of 23 million. So this puts things in perspective that it's still low, it's still slow, but it's not as slow as people make it up to be. And then the false narrative that is also presented in many of the committee meetings is that 40,000 white farmers own 80% of all the land in South Africa. But if you take South Africa's surface area, it's 122 million hectares, with roughly 64 million hectares of agricultural land in freehold territory or in white hands. That's roughly 50% of the surface area currently in white commercial farmers' hands. But even the 40,000 number is problematic, because that's only VAT-paying farmers, and we know that there are probably 130,000 commercial farmers making a living from agriculture, and many of them are also Black. So you can't just say that the 40,000 or 130,000 are white farmers. So the statistics is problematic, and therefore one needs to be very careful about how you motivate the need for such an amendment based on wrong statistics. But even though we've reworked the statistics, it is slow. It is not what we wanted to have, because the 30% target was already earmarked for early in the 2000s. But the real reason for the slow progress is the government system, the bureaucracy, the delays, the patronage, the political influence, the poor decision-making, and obviously the poor budgeting and execution. This is the real issue that we should have addressed in the context of speeding up land reform. But it's much more comfortable, much more politically opportune to deal with an amendment, because you look like you're doing something, but you're not addressing the real problem. If we've implemented the systemic process of land reform back in 1994, 1996, which most people agreed upon, then we would not have dealt with, we did not have this problem. The fundamental issue is that we all say and the experience globally, if the state acquires land, it will be very bad and very poorly redistributing the land to individuals. We see that happening in the plus environment, where the land is not transferred very quickly to everybody that requires land for equity's sake. So the argument for the amendment plus the content of the amendment is flawed. And let me just pay a little bit of attention to the content of the amendment, and specifically, Annelies, your focus on the custodianship, because I think that's your real topic for today. And you referred to the article that we've written back in June in the Business Day, which Theo Boshoff has rightly argued many of the important points. So custodianship globally is referred to and used in the context of protection of natural resources, where the state protects this natural resource for the benefit of society as a whole. There's no argument about who should utilize it. It is utilized by society as a whole to improve the livelihoods and improve the well-being of society. The other mistake that people sometimes make in terms of using the word custodianship is to compare it with customary tenure, as we know it in the former homelands. But that is also problematic, because many of the ways that it's done in customary tenure is not the same as custodianship. A third problem with the concept of custodianship is the whole issue of the burden it will put on the state in terms of managing the rights to land under the custodianship rule. You can just imagine how the conflict of overlapping rights that will happen now in this whole process, and not to mention even the confusion that will happen in the deeds office. We all know how long the deeds office take to register a current title deed, but now imagine we, by a stroke of a pen at midnight, say 2024, we have constitutional change, and on all land rights revert to custodianship by the state. So technically all of those title deeds need to be transferred in the name of the state. How long will that take? How will it happen? It will definitely place a possible burden on the state. But the more interesting part of it, when the land rights are transferred away from individual rights and away from private property, there will be no legal basis for taxes for local government. So the issues of land tax, municipal tax, all of those will disappear, and therefore the financial situation of many of the municipalities that are already in dire straits will just be adversely impacted. But then finally, the president is very hopeful that people will invest in South Africa. Obviously, under such a new situation, all the investment talk will disappear, and we basically won't have a expansive investment in South Africa's economy, which will definitely impact on employment creation. It will impact on expansion of our economy, on the growth of the economy. So one can just foresee that how the one element of the government's initiatives are not talking to the land custodianship debate in itself. So it is very difficult to speculate about the context and how this will play out. But the feeling that we have is that most people with rational minds would think this is unworkable in the context of South Africa's trajectory. There's a much easier way of dealing with this. And I think many lawyers, including Professor Hermine du Plessis, already argued the case that the amendment is not necessary. We can do most of the things that is necessary for land reform to be speed up through a bureaucratic change, a government system change, and through the expropriation bill that is also on the cards. So there's no real need to spend more time on this. And many commentators have already written about how 3 to 4 years of time and effort have been wasted on this, seems to be really impractical. So Annelies, that's my short input. As you could see, there's not a lot of economics related to it, but I think we can all see the potential problem from an economic point if we go ahead with this weird amendment that is in any case outside of the mandate of the committee that was initially set.
Weird indeed, yes. And yeah, I think it came as a surprise to many people. And as I say, there's so much that one doesn't understand, but the practical implications. I think we're all hoping that this will not get passed. But the practical implications, I think, really needs to be thought through. But I'm going to give over now to Advocate Johan de Waal to give us a bit of a legal perspective.
Morning, Annelies. Am I unmuted?
Yes, indeed.
I had to send my user ID to you, but I see my neef, my cousin Johann de Waal, is also on here. And I thought maybe you unmuted him, because if you do that on this topic, it's not going to be 15 minutes, I can tell you. But I've only got one point to make this morning, and I've got 15 minutes, which is ample time. So allow me a bit of background before I make my point. And perhaps we should start. We're not dealing with EWC, as you said this morning, Annelies. We're dealing with state custodianship. So I thought I'll start just to read the language of the two clauses we're dealing with, which is the amendments or the proposed amendments to Section 25 of the Constitution. And the first one is the new clause 4A, which reads as follows: the land is the common heritage of all citizens that the state must safeguard for future generations. And then you find the new Section 25(5), which is proposed to read as follows: the state must take reasonable legislative and other measures within its available resources to foster conditions which enable state custodianship of certain land in order for citizens to gain access to land on an equitable basis. Now, where does this come from? Where does this language come from? And for me, it undoubtedly comes from the mineral rights legislation, and more particularly the Mineral and Petroleum Resources Development Act of 2002. And let me just perhaps read to you what Section 3 of that act says. Its title is Custodianship of Nations' Mineral and Petroleum Resources. And Section 3.1 reads as follows: mineral and petroleum resources are the common heritage of all the people of South Africa, and the state is the custodian thereof for the benefit of all South Africans. It's the common heritage of all people, and the state is the custodian thereof. So I think you can see what was said about mineral and petroleum resources is now said about land, or something similar to that is said about land now. And so we've got to go back to what the courts have decided about that Section 3.1 of the minerals legislation. How did the court interpret what that means? And here we've got a series of constitutional court judgments which explain to us what this means. And it's unequivocal what those judgments say. what it means is that private ownership of minerals is abolished. It's finished and clear. What was a private mineral right has now become something akin to a liquor license or a fishing permit or something. And I'm not exaggerating. And I want us to maybe just stop here for a moment. And if I can read to you what the Constitutional Court, we know that this litigation or decision started with AgriSA's case. But the later judgments make quite clear what I just said. And if we look at the decision case in 2014, let me just read to you from that majority judgment. It says, private ownership of mineral rights is incompatible with the principle that mineral and petroleum resources belong to the nation, and that they are held by the state as custodian. And then more, just another little sentence. The MPRDA, that's the act I just read to you from, abolished private ownership of mineral rights. Ownership of all mineral and petroleum resources is now vested in the nation. It's vested in the nation now. And so the concept that we're dealing with here is not expropriation, as we know. It is saying that the state will not become the owner, but this construct called the nation now becomes the owner of land as it became the owner of mineral rights. And because the state doesn't become the owner, there is no expropriation. And therefore the question of compensation does not arise. And I think, as you know, that was the finding of the majority of the Constitutional Court in the AgriSA case. Now, one doesn't have to be a rocket scientist to say that, wait a bit, but isn't this really just expropriation without compensation in a different way? I mean, I'm not saying I'm expropriating from A to give to B, but I'm now saying I abolish the right that A had. I, as state, can now allocate a license to do the same thing, to use farmland. And in this instance, I can choose whether I want to give that license to A or B. So this is what the minority of the Constitutional Court in the AgriSA case said. They said, but this is just expropriation in a different form. And if you can do that to mineral rights, then of course you can do that to any kind of property, or for that matter, all property. You just abolish the concept of private ownership of that particular kind of property. Now, this is the essence of what the EFF's argument was. And they were coming in their submission to Parliament and saying, you must do with agricultural land what you did with mineral rights. That is the essence of the submission that they made. And the consequence of that is that with a stroke of a pen, there's no more mineral rights. And with a stroke of a pen, there's no more private ownership of agricultural land or land. And this was the proposal. This is what they urged Parliament to do. Now, why are they now unhappy, and why are they not supporting this bill? And I think the reason for it is that it's by no means clear that it is doing to land what was done to minerals. It's not clear that it is so. And if I can just go back to 25.5 again, and just read it perhaps slowly again, the state must take reasonable legislative and other measures within its available resources. And if we can just stop there, within its available resources, that seems to imply that there must be some kind of a payment. Now, if I go on, to foster conditions which enable state custodianship of certain land. So it seems to imply that there will still be another step which will enable custodianship of certain land. So on my reading of it, it may just mean something like this, which is that the state can now build up a pool of land. It can use its own land, it can buy some land, or it can expropriate some land, but it can build up this pool of land, which it can then use for purposes of this notion of state custodianship and give people access to that land. Now, of course, if this is the interpretation, then it is relatively or perhaps even entirely benign. It's fairly innocent because the state can do that anyway. But now I just want to get to the one point that I said I have. The problem is that we just don't know. We just don't know whether that is what it means. Either on the one extreme, it can mean what the EFF says it means, or something akin to that, where certain land can be designated, and then it abolishes the private ownership in respect of that land, and it then falls into state custodianship. Or it can mean what I say, which is that it's just introducing this notion of state custodianship, which the state must then acquire property purpose. But it creates, if adopted, will create enormous uncertainty. It will certainly, as I think Prof Kirsten's already very good reason, i.e. that it means something along the lines of what the EFF wants. It may also deter investment for no good reason at all, if it's interpreted like I said it should. But the fact of the matter is there will be an impact and there will be uncertainty, which wouldn't be a good thing. That's the one point, Annelies, that I've got. Thank you.
Thank you very much. That has been really, really insightful. And interestingly enough, in some of the committee meetings, some of the last committee meetings, the ANC member, I think it was Honorable Gaba, actually gave that kind of interpretation, because he said that it was a temporary kind of a taking, a temporary custodianship that the ANC had in mind. So that is very interesting. But be that as it may, you know, even if there is a benign kind of an interpretation, we only need to look at the track record of government acting. And I mean, in that article that I referred to by Prof Johann Kirsten and Theo and Wandile, they made the point that the Ingonyama trust land and the traditional land in the old homelands areas, you know, was actually a form of state custodianship, and you know that clearly has not been good for agricultural production in those areas. And I think Prof Vivian might refer to it, but also in the urban context, I think there are examples of state land that the state has held on behalf of people, but that was not well managed and that did not really empower anybody. So I think that is a danger, even with a temporary kind of taking. We can also look at the PLOS program, where government acquired land, then held onto it on behalf of the beneficiaries, but for the most part, those beneficiaries had no tenure security. Many of them didn't even have proper written leases. But very interesting. Thank you very much, Advocate de Waal. I'm going to give over to Prof Vivian now. Prof, you have a presentation. Manu, I've just sent it to you by email. Can we share it from our side, maybe?
If you can share it from your side, that would be wonderful. Otherwise, I'll try from my side. And I think
okay. Now Manu says he will share it. Thanks, Prof.
You're much better with computers than me. Okay, I don't have a presentation, so I just have the points that we're going to discuss. So instead of me sort of trying to look at them, I thought I'll put them on the screen so you can see which points I'm talking about. So it's not really a presentation, it's just an aid memoir for myself, so I know what I wanted to say. Okay, as you know, we're talking about state custodianship of land, and that's just something who I am, Professor of Finance Insurance, Wits University, and in this capacity, a member of the Free Market Foundation's Rule of Law Advisory Committee. I'm also on the board of the Free Market Foundation, so I've got strong connections with the Free Market Foundation. Free Market Foundation, as we will see, also made some submissions about the amendments, and I was the author of one of those submissions, which dealt really with the state custodianship issue, which came in quite late, as we know. So I thought what I must do, although we are going to talk about state custodianship of land, that's really not the issue at hand. And I think Adv de Waal has already sort of pointed in that direction, because what's appearing now in the Constitution shouldn't be there, and what is there we can't really understand. And so we can only really have a debate when we try to understand later on what we can't understand now. So I hope you understand how chaotic that is, because that's precisely how chaotic it is. But the immediate problem at hand, which is not the one we're going to discuss, is the amendment to Article 25 of the South African Constitution by the insertion of these clauses which Adv de Waal has already spoken to. I just want to put them on the table so you can focus your mind on it as we then move to the real issue. Now, Adv de Waal has already spoken about this article, but I just want to put a bit of emphasis, which I don't think has actually been seen, and the importance of that becomes a little bit later. And that's the issues which are in bold. So Article 4A, that's the insertion. And I'll just give the relevant portion. The state must take measures which enable state custodianship of the land. So unlike other things, this is placing an obligation on the state. So when we get to expropriation without compensation, we can argue this is really not a debate. This is a duty of the state after this comes into the law to come take everybody's property. And if you think it's not, then you go and try and explain to a court what the word must take measures mean. And Article 5, which we've already seen, also already added, the state is a common heritage of all citizens that the state must safeguard. So when the soldiers come to take the farms into custody and you say you can't come, they say, but look, you know, we have a constitutional duty. It's inserted in the Constitution for us to take the property into safeguard for further duty. So unlike any other constitution in the world where the Bill of Rights is there to protect rights, we now, with these inclusions, have in the Bill of Rights something which takes away everybody's rights in the Constitution. Nogal, not even in an act of Parliament. And that's why I want to emphasize the point that articles falls within the Bill of Rights. It's a very wrong section to have any of these words. The Bill of Rights has a completely different function. This was also a last-minute inclusion. It was not part of the original mandate given to the ad hoc committee. This came, I think, when it became clear the EFF had this in mind. As with the original one, the ANC thought they would try and steal their thunder, just insert it. But it has enormous implications for good. So it leads to the broader issue of the notion of state custodianship, and the Free Market Foundation's made submission opposing the EWC in its original proposal, and then the latest edition. So the debate, I think, could have been, let's just talk about the impact of this amendment, but it's not. is about state custodianship. So let's just talk a little bit about state custodianship. So if I can get the next slide, that would be wonderful. Okay, now it's the problem of now the idea that somehow we are going to take property into custody. Now, I think most of the discussion and debate that we have is say, let's have a look at the reality of the South African situation. Let's have a look where we are with the land reform. I take a much broader view. I just say, just look what happened in history. This is an argument we've had over and over and over and over again, and it's come out always on the side where it should be, and now we're going to go backwards. And the side where it is the unchallenged optimal outcomes of a free market. Now, as any society that you ever want to look at, and I'm not going to try and give you that sort of analysis, the ones which produce the best outcomes is the one which has the free market. And I could give you, quotations from theory and literature going back 200 years, right to the present day. So there is little doubt on that. What we have in recent years, last 10 or 20 years, is an increasing intervention in the market by the government. And that intervention in every case has produced suboptimal outcomes. So that's what we want, and that's the position of the Free Market Foundation. The free market is the optimal position. Now, if we accept that, then we have to say to us, what is the essential role that property rights play in secure the free market? Well, obviously, it's an absolutely essential role, because what is the free market? The free market is a market of exchange. What are you exchanging? You're exchanging property of a variety of forms. It could be land, it could be your labor, it could be intellectual property rights. It doesn't matter what it is. And if you do not have the security of property, then we can't have a free market. So the moment you move to interfering with the free market, then you are then going to end up in a suboptimal position. All you need to do is go and have a look at, compare, East Germany with West Germany when the wall fell, and ask which one performed better. You can ask the people on the East Germans who used to go look over the wall to see what life really looks like compared to the life that they had. So we don't need to have a current debate about let's look at the current situation. We just need to look at history, and then we'll say that's going to happen. Now, the new kid on the block, which is this thing that's just been thrown in at the last moment, is the idea of state custodianship. And I agree, it comes from the previous case, which a rather strange constitutional court case, which argued there's no expropriation if you just take property into custody. It's really a weird argument, which I don't think would get much support from anywhere else. So we can have a look at situations, and the one which I've put is the one of Khaya Lam, because that's the one which the Free Market Foundation has been involved in for the last 20 years. Started, I think, the brain movement and behind it, I think it came from Leon Lowe, who's the president of the Free Market Foundation, and others. Now, what you will know, if you want to have a look at how state custodianship works, and then just take the position of the township, what we used to refer to as townships. I'm not sure what the political correct word would be today. There would be an example of state custodianship. There, all the houses which they had all belonged to the state, and the state used to let them out. And what happened is they deteriorated. And I worked in Soweto for 10 years, so I actually understand what happened much better than most. So it's quite clear. And if property is not owned, there's no incentive for people to maintain, improve, and do something with that property, including improving it so that you can pass it on to your dependents after you die. So, as you look after these properties right to the life. So in 1994, the idea was these township homes would be handed over, and the point already been made, the government, when it says it's going to do something, it finds it's unable to do it. And if it's going to do it, it takes 20, 30, 40 years and nothing has happened. So Leon Lowe and the Free Market Foundation decided what they would do is they would have a look at this and see if they can find a way of giving private ownership to the individual title deeds to the people who are in current possession of those homes. And they managed to get it down at a very nominal price of really 2,600 per house, collect that money from the private sector, and then negotiate with the various municipalities and hand it over. And they've been doing that very, very successfully. So we have a very good example of property in state custodianship not working, and where it should go and what will happen after that. So we will get everything all the houses now be in a state of improvement, can be used as security, can be passed on to descendants, all the things that you get from the property rights which are referred to in the previous paragraph. Now, what happens when it's in state custody is actually quite well known, and there's a very, very good paper which was published in a very famous paper in 1994 called The Tragedy of the Commons, and it has the argument which I've given, but it shows you from history how that happens. Is if everything is belonged by the state and therefore they hand it out to other people to use, but they can't own the property rights in it, then there's first of all, there's no incentive to improve it, and there's incentive just to destroy it. And so eventually you end up with deserts and overfishing and overtrading. The fishing would be an example. That's why, you know, today we've increased the coastal area to 200 kilometers, because otherwise what was happening? Ships come from around the world and then they have an incentive to get rid of every single fish that you've got. There can be no improvement. So for us to even think about state custodianship would be to ignore every lesson which we've got in history. And I suggest you go and read the Tragedy of the Commons and see the arguments as to why we need to do. The solution to the Tragedy of the Commons was private property. Just let everybody own property so that we can have property rights and people can then transfer those property rights, and in that way it goes there. So for us to go to even talk about state custodianship would be simply a return to the past. It is a move in a completely wrong direction. And obviously when that move is made in the wrong direction, then you must know that there are incentives to go in that direction. Jean-Jacques Rousseau, a great French philosopher, wrote an interesting essay called On the Origins of Poverty. And when I see this proposal, and I think what Jean-Jacques Rousseau said, he was right and this is pre-French Revolution. He was right on the lessons from then, and he's right on the lessons going forward. He said, people do not fight oppression. What they do is they fight to become the oppressor. So people do not put in a system so that they can improve the lots of everybody else, but there's a benefit in the system which they want to put in. And as we know, South Africa has become mired in corruption, and there's nothing that's going to give you greater corruption than the idea of state propertyship. That's a lesson we have already learned, and we could talk about that. So I would say that everything is wrong about state custodianship, but to emphasize the point, and that's why I want to end up on this last session, is the issue which is on the table at the moment is the amendment to that constitution. So I just want to quickly give you, I'm not going to go in great detail it. Part of that objection was also to the idea of state custodianship, and I'll give you those objections in there. Now, my colleague Martin van Staden, he did the main submission, and he relies on what's known as the Basic Structure Doctrine. And that is an interesting doctrine, and that doctrine says that a constitutional amendment can be unconstitutional. So it is quite possible, if you amend a constitution, that you are going to end up with a constitution which is unconstitutional, and therefore you will be able to challenge that in a court to overturn the unconstitutional aspect. It's a doctrine which has evolved from India, and it's now been applied in different parts of the world. And I think that's the correct doctrine. And so I think if any of this goes through, then one would have to seriously consider challenging the amendments in the Constitutional Court, and all the arguments we put forward that can then be argued. I think the way that's much easier for anybody to see it is the American approach, which is called the unalienable rights approach. And I think that one is correct. If you have a look at the United States Constitution, when it first came out, it had no Bill of Rights. And that wasn't an accident. All the debates which took place, or the main debates, have been collected and published in what's called a Federalist. And Alexander Hamilton was a great speaker and proponent on this. When it came to the I think it's the penultimate document in the Federalist, he then explains why he didn't think we should have a Bill of Rights in the American Constitution. And he said the Constitution itself is the Bill of Rights. So the whole Constitution is to protect it. And then through a series of amendments, they then brought in the Bill of Rights. So when we talk about a Bill of Rights, I think the Americans get it right. They get it right. The United States Declaration of Independence says that everybody has unalienable rights. So they have got these rights. Just think about it. Who gave you the right to life? It's not a constitution, no document, no government. You were born with the right of life. And that's why they said we are endowed by our creator with certain unalienable rights. So a constitution doesn't give you rights. But your rights can be abridged, they can be limited. So the Bill of Rights sets out when that limitation would take place. Now, of course, they have to be abridged. If you went and murdered somebody, then of course you can be in prison. So you can't say, look, I have a right to liberty, you can't put me in prison. So the Bill of Rights will then set out the limits of that abridgment. So when we turn to the Bill of Rights, the Bill of Rights must say, okay, that's a legitimate abridgment. So that's what we should be looking for, not for our rights, but when can it be abridged. So they introduced the Bill of Rights through a series of amendments, and if you have a look at their property clause, which is very good, no person shall be deprived life, liberty, or property without the due process of law. Very simple, very clear, not 4 pages of it and 20 annexes and all the rest, just simply said. And then it says property can only be taken, but for one use only, public use, and on the payment of just compensation. Now, if you read that and you think, I think those are very beautiful words, that is fantastic. And you're quite right, those words came from a Dutch writer, Hugo de Groot. So we have our Roman Dutch writers who have influenced the American Constitution, and we should have used that and brought the Roman Dutch writers back to our Constitution. Okay, so think about what the American Constitution is saying, and think about this, the following scenario which I will put before you. The army arrive and they come to take your farm. So between you and the farm, what is there that stands? Now, in the American situation, there you can see Constitution stands in the way. Public can only be taken for public use. Why are they coming to take it? For public use, and when? On the payment of just compensation. No compensation without, no expropriation without compensation. And also, it is quite clear that there's only one single purpose which we've got to get. Now, let's take our Constitution after the amendment and ask ourselves, when the troops come and take, or soldiers come to take your property, what do you rely on? Can you now go to our Bill of Rights and say that your property cannot be taken other for public use and only on the payment of just compensation? No, you can't. And so now we could talk about the rule of law. And I must say that the chairman of the Free Market Foundation's Rule of Law Committee is Rex van Schalkwyk. And at one meeting that we had, he put a definition on the rule of law. And I smiled to myself because nobody has ever been able to define the rule of law. So it defies definition. And the last person who tried was Tom Brigham, Chief Justice of England. And he tried to present a paper on the rule of law at Cambridge University and found out he didn't even know what it meant. So he ended up writing a book. So in Tom Brigham's book, if you want to know what the rule of law is, all you have to do is say, read my book, it's 10 chapters, and that'll explain it. It doesn't help you at all. Rex van Schalkwyk is a fantastic definition. The rule of law is the barrier the law sets against tyranny. So when the soldiers come to your property, what stops them? In America, there's a United States Constitution that stops them, and that says that they can never get across that barrier. They will not be able to penetrate that barrier. So for 200 years since the United States Constitution was written, no attempt has ever been made. What are you going to have in South Africa when the soldiers come? Okay, let's look at the Bill of Rights. The state has an obligation to take your property into custodianship. How is that going to protect you? It's not going to protect you at all. So what happens is we don't have a Bill of Rights and we don't have protection, and we simply do not have a constitution if that amendment goes through. The only thing that surprises me is why the objection to that amendment was not a lot more vigorous than what it was. There was a lot of objection, but I would have made it much more vocal and much more vigorous to say that amendment goes through. There is no constitution. So from now on, don't talk about a constitution. Just put it in a small c. It's just a piece of paper which has no meaning. And when the soldiers come to expropriate property without compensation, there is nothing standing between you and those soldiers. In the United States of America, done correctly, thanks to Hugo de Groot, our great jurist, the Constitution stands in the way. That's where we're going to go. So if I can summarize, state custodianship, economically speaking, has been tried, rejected. We evolved out of that. That's where we had the Commons in England, and then they had the Enclosure Act and all of those things because the Commons did not work. So we're going to go back to that. We were not really trying to go back to it. I think you'll find when you sit back 50 or so years later and you look at that and you say, let me read again Jean-Jacques Rousseau's Origins of Poverty, and you say, okay, I will understand why South Africa became poor. There was no attempt here to improve the lot of anybody. The oppressors wanted to become the oppressor. That's all they wanted to do. And then they will laugh at this constitution and say, whoever thought this was a constitution did not have any idea what is a constitution, because with these amendments, it would make it a complete failure. I hope and I trust that if the amendment goes through, all that will mean is the Constitutional Court will overturn it and make my colleague Martin van Staden very happy to say the basic doctrine structure does apply and does work in South Africa. Thanks a lot.
Thank you very much, Prof. And indeed, the Free Market Foundation has been very vocal and has also been instrumental in getting a lot of concerned organizations and parties around the table. I attended a workshop, I think it was November last year, that was hosted by the Free Market Foundation around Section 25 and property rights and all of that. So thank you also for that role that you've been playing. So we have half an hour left now to try and dig into the detail and have a few questions. So this is the speculative part, Prof Kirsten, and I fully realize you all professional people with reputations to protect. So I understand that you don't want to speculate too much. But I'm going to ask you if you are willing to speculate for us a little bit about the potential economic implications and implications for our sector were this worst case scenario, the worst case interpretation that Advocate de Waal has spoken about, that private rights property rights basically get extinguished through this amendment. If that were to play out, what would the impact on the sector be? I see also there's a hand up from our president. We're not planning to take questions from participants, but you must indicate to me whether you are, Pierre, I also don't know, are you want to ask a question or do you want to make a contribution? If you could just maybe let me know in the chat or so, and then we can try and accommodate that. But Johan, if you want to try and go there as far as you're comfortable to do so.
Yeah, it's so difficult to get one's mind around this because the way that Advocate de Waal explained this now, and you think about the issuing of the license to use the land and how the administrative process will just be so complicated that it will end providing a lot of uncertainty to anybody else. And then the question is the license to be issued to use the land. What is the time dimension of it, the term of the license? Will it be 5 years like they do on the plus land, or 3 years? Therefore, it means that any of our high value crops, our long-term crops, will not be able to expand the operation, because by the time that you get to maturity, 7 years or so, you will have lost your license. So the issue is very complicated, and therefore, if it's not a 99-year lease arrangement, then we're basically not going to have anything. So, and some of the arguments that the EFF made and presented to the committee has been the sort of Mozambican example of 99-year leasehold. One can probably live with that, but again, the Constitution and the Bill of Rights and our property law should somehow protect those rights from utilization by others. So a leasehold is an example of where the land is held in custodianship, perhaps by the state, but you have a 99-year arrangement to utilize the land, and you can probably earn your returns from your investment on the land in that period. So I am just thinking about the confusion that would arise, and I agree with Prof Vivian as well, the uncertainty that will arise unless all of these things are defined. But the more substantive issue is that all of these amendments are contradicting one another, and in any case contradicting our Bill of Rights. So it is very difficult to see how this can play out practically. But apart from that, it's very hard to speculate, because I don't even want to go there to be able to speculate. So that's my 5 cents worth of comments.
Sorry, just struggling with the unmute. Thank you very much, Johan. No, I think that is quite useful as well. My sense is that it may well open up the door widely for corruption as well, if you have a system of permits and licenses. So I think that is also a concern. I've got a question then for Advocate de Waal. Once again, I'm asking you to speculate. So if you're not comfortable, you're welcome to indicate that. But given what has been said, and once again, if we focus on your worst case scenario interpretation, would such an amendment pass constitutional muster? And it can be very technical. I know this whole debate around the doctrine that Prof Vivian has referred to and all of that. And I think there's definitely process flaws in coming up with the amendment, which parties that will want to litigate can focus on. But your view on the amendment itself, and whether that is compatible with the whole of our constitution?
Yeah, let me maybe just start by saying what I understand to be the worst case scenario, which is what it would mean is that in the top part of Section 25, you have now expropriation, including expropriation without compensation in certain cases. That's dealt with up there. But now in the bottom half of Section 25, starting with 4A and going to 5, subsection 5, you now have a state custodianship, which is a parallel process which applies to land, and where for all practical purposes then EWC is not required, because it reverts to the nation, as I think I said. So the expropriation without compensation in the top part would then apply to other forms of property only. So maybe shares, whatever takes people's fancy, that can now be in some cases expropriated without compensation. But for agricultural land, that whole debate about EWC falls away, as it did with the mineral rights. And this would then, at least to some extent, allow the state to, for instance, designate part of a farm, maybe the unused portion or whatever, and say that now this is designated, it falls into the custodianship, and I'm opening a license process. Anybody can apply to go and farm there. And I'm giving people access, or you must apply for a license to farm on your own land. And that's now a competitive process and a fishing license and so on. And the question is then, and really I haven't looked at this recently, but the question is whether that interpretation is inconsistent with Section 1 of the Constitution. There's only one argument, which is, does this kind of amendment change or violate the rule of law in Section 1? And that's our only candidate. Fortunately, or unfortunately for some, and the rule of law has grown over the last 20 years in a way that it means quite a lot of things. For instance, it means it includes a notion of equality, and it includes a notion of certainty, and it includes all these things, which one can then say this new amendment aims to undermine, because it is, in effect, sidestepping the expropriation clause. It's arbitrarily selecting a certain kind of property where you can now just effectively expropriate without compensation and do with that as you want. So yeah, certainly, and I mean, that has to be the argument, and that has to be the strategy, I think, which would be to say immediately that this amendment must be challenged for inconsistency with Section 1 of the Constitution and the rule of law in particular. Sorry, I went on a little bit there.
Thank you very much. Prof Vivian, we like quoting that International Property Rights Index in our submissions. We've done so in more than one of our submissions. And there is a clear indication there that there's a link between the measure of protection of property rights and tenure rights on the one hand, and per capita income on the other. Is that something that you can confirm from your experience also with Khaya Lam? And in conjunction with that, would you like to say something around the possible solutions that you see? Clearly what is now on the table is absolutely the wrong way to go. But what is then the right way to go about land reform in your view?
Yeah, look, there's a definite correlation between property rights and prosperity. I mean, you just need to look at the per capita income from about 1500 onwards and plot it, all the different sort of countries which had property rights, abolished the idea of custodianship rights, which is what happened there with the commons, and then look at the per capita income. The three countries went up, the others stayed the same. I mean, so it's a non-brainer to say that we can't. If you're trying to get prosperity, you can't go down that route at all. That does not give you prosperity. So I think we can take it. Now, the point which is already made, which I think the Khaya Lam exercise is quite good. People have wanted to have title deeds in the townships for 30 or 40 years. They've been promised it for 30 or 40 years. It never came. So the government there was, up to this point of time, was quite happy to give them property rights, but they couldn't do it. So it'll be exactly the same. If you now say we're going to take the entire land, agricultural land, and put it under custodianship, and give it out to licenses, and not only that, it should be clear to anybody that will be a hive of corruption. As for example, when we've had housing lists, housing lists go on forever. And then if you have political connections, you can get onto that list. Don't have them, you don't get onto that list. So the net result, it will not work. So the individuals who have got the opportunity to get the title deeds in the township, that's what they want. And that's what the Khaya Lam project is doing, is giving it to them. Now, if you say, let's introduce, you're going in a completely opposite direction. You've decided something is good and has to go in that direction. Now you're going to go back in a different direction. So it won't. My real concern about, which is a constitutional concern, is I don't think you can put state custodianship, what they've done, into the Bill of Rights. You'd have to first have a policy position, say this is what we have to do, and when you've done that, then say how does it affect the rights, and then amend the Bill of Rights. So you've treated the Bill of Rights as if it's the same as any other part of the Constitution. But as I've already indicated, in the Bill of Rights, you put the state has to implement state custodianship. In other words, it has to take your property. By law, it has to, by constitutionally, it has to take it. So obviously that can't be left in the Bill of Rights. So that has to be challenged in a constitutional court to say that's wrong. And it's wrong because they didn't work out the process. I mean, we are trying to have a discussion today about what's the implications of it. Now, that's the discussion you should have had, and out of that discussion, you would have said, okay, we are now going to bring out national legislation, and then you're going to say, okay, we'll bring out national legislation. Does that infringe the Constitution? We're going to look at it. But no, you go directly to the Bill of Rights and you say the state must go and take everybody's property. As I've indicated, put that into the Bill of Rights, you have no rights in this country. The Constitution's gone. I mean, the army arrives and says, we're taking your property. What defense are you going to have? You're going to say there's some national legislation? I said, no, what does the Constitution say? What does the Bill of Rights say? The Bill of Rights says they have to. It goes worse. In accordance with its resources, the state says we have no resources, therefore we will pay nothing. We just own everything now. So that amendment to the Bill of Rights is the nationalization of all land in South Africa. The nationalization has taken place in the Constitution. Now that shouldn't be allowed, and that's got to be challenged. So you have to get your mind about how we're going to go and challenge that. But I mean, and it was an afterthought, it's like all afterthoughts. You shouldn't have an afterthought. You should work it out. So the way to work it out is to say, okay, we now propose to have the idea of state custodianship. Here's our white paper or our green paper, and let's get comments on it. We'll move it into a white paper, and let's get those comments. No, not this lot. Knock out straight into the Bill of Rights. Let's just nationalize everything, and people don't understand it. And so I say, I don't understand why there wasn't an outcry at this attempt, because this attempt says there is no more property. And even expropriation of that property, if you read what they've said, is will there be expropriation property? Well, it will be decided in the national legislation. You're supposed to check the national legislation against the Constitution. Now you go and check the Constitution, it says, no, you can do whatever you like. So I get to my position. If these amendments go through, we don't really have a Constitution. We mustn't use a capital C, just say C, and then we simply put in inverted commas. It's just a piece of paper which has got no real meaning at all in law, except as an instrument of oppression.
Our president, Pierre Khaya, has asked an opportunity also just to say something and maybe pose one or two questions, and then we're going to deal with those and then close. Thank you. Pierre?
Thank you very much, Annelies, and thank you for putting together this webinar today, because it's such an important topic. If we look back at what's been happening after the last 20 years, we've been on the defense all the time. We recognize what is going wrong, and we're on the defense and trying to fix it all the time. But what Prof Vivian said today made a big impression on me, in the sense that we're all free market people. If you're a commercial farmer, you look at it from a free market foundation, and many of us are, you could call us libertarians too, I suppose. And we believe that property rights is the cornerstone of economic growth and so on. But we also know that politics and politicians is about power and not economics. So if it's possible, and that's where I would like the panel to help us, point us in a direction, it's about doing and not talking. Because I listened to what Prof Vivian said, the Free Market Foundation did about properties and the whole issue of getting the deeds in the hands of the people who should have it, so that they can use it as collateral. What's happened to us now, and it's happening, and it's as if it's a train coming down a tunnel, and the light, it's not a light in the tunnel, it's the train that's going to run over us, is the sense that we land ourselves in a position where we defend and we do not show what private property rights can actually do. And in the whole issue of whether we want to call it transformation, or whether we want to call it, like John Purchase does, inclusive growth, and whether we want to talk about what Wandile says, patient capital, whatever way we look at it, we will have to demonstrate that private enterprise, private property rights, private business will actually do it for us. Now, sometimes I wonder whether the ball is our side of the court as farmers, as commercial farmers, to make this a success, or whether it's such a multifaceted subject that Adv de Waal said how he sees it, and I agree with him. He sees it the way that I see it the way that he sees it. But there's nothing that's been said that we don't agree with each other. But fact is, What do we do? How do we actually, we can go to court and we can do all kinds of things, but the whole issue of poverty and everything else in the country is pushing this thing in a certain direction that's ideologically based and not practically based. And we will have to change the question to be able to get the right answer. In other words, it sounds to me that we will have to be practically involved in showing that this can be different. I would like the panel just to tell me whether I'm looking at it in the right direction, or whether this is something that is out of the ambit of the commercial farmers section of our country to show or to implement or to make a success of, or to negotiate for, or is it something that we will have to just keep on fighting in the courts and be on the back foot all the time? Thank you, Annelies.
Thank you very much. So I see we've got 10 minutes left. So I'm going to allow each of the panelists, starting with Prof Kirsten, to try and respond to what our president has said, but also then to make your closing remarks.
Thank you, Annelies. Your question to me in the SMS is probably related to the president's question about what do we do. And I want to start off by my closing statement saying that if we think of the importance of the so-called freedom of South Africa post-1994, one fundamental aspect of it was to bring private rights, specifically land rights, to the majority of the people that were disempowered, disenfranchised through the apartheid legislation. Because if you go back to the history of the ANC, the focus on private property has been part of their struggle for many years. You go back to the 1800s, many black people had private rights to land that were taken away in the post-1910 dispensation. So the whole struggle, in a way, was aimed of bringing fundamental rights as per the Constitution to black South Africans. So now you have done that, and now you want to take all of those rights away, just as black South Africans are obtaining private property. So that is quite difficult to understand and difficult to do. But Pierre's comment is quite right, and it's something that bothered me for many years, is the fact that we always, as the commercial agricultural sector, be on the back foot. We're trying to defend, trying to take things to court, but our proactive action is rather limited. And if we had an inclusive agricultural organization, we would have achieved quite a lot in terms of the political standing. If we had, at grassroots level, at local level, at provincial level, assisted our commercial farmers to do land reform on their own terms, then we would have achieved a greater number of black farmers with property rights, private property rights, that could have helped us in this case. There are initiatives across South Africa which have brought that perspective to the fore and actually contributed to bringing and empowering black farmers into the commercial value chain through collaborative arrangements. And I think I always raise the Witzenberg initiative as an example where you do things without having to bother about the state, without having to worry about funding from the state, but that the exercise of a local level driven land reform without the engagement of the politicians is always going to be more successful. And this is where organizations like AgriSA South Africa can take the lead. And Pierre knows the philosophy of Mohammed Karan. We work together a lot on those dimensions, and it is those philosophy that I see being implemented where a land reform agency can actually play a role in terms of facilitating that local design solutions, not engage with it, facilitate through good funding, through removing all the barriers in legislation that can bring about donations, bring about facilitation, bring about tax relief, etc. All of the dimensions that would bring a behavioral change. A lot of this is behavior issues, you know, and people sometimes in policy and legislation and in constitutional changes forget about how that will impact on the behavior of the agents in society. We want to change behavior, so therefore you need to think about your incentives and your penalties. And people are strange, you know, if the incentives are appropriate, they will react and react in a positive way, and sometimes by doing things out of your own interest could benefit society and benefit the broader objective. But that's why it's very important to structure the incentive that it feels like it's benefiting you, but it's in actual fact benefiting society. So the objective of your incentive should be clear. The mechanism about how you do the incentive should be done in such a way that farmers and local farmer organizations take initiative in their own hand, and you're utilizing these incentives to bring about the transformative change that you all need.
Thank you, Johan. I think those were very fitting final remarks from you. Advocate de Waal?
Yes, as I understand, Pierre is talking about or asking about practical steps and not just talking and so on. Firstly, I think that one doesn't want to be in a situation where you want this thing to go through in this form and then try to challenge it with reference to Section 1 and the basic structure argument. I think by then the damage would have been done, and I think everything must be done to stop the amendment to go through in this form. And perhaps the starting point must be there to just try and get from the ANC an explanation of what is intended here, what do you want to achieve here. And if it is something along the lines of the benign interpretation that I suggested, well, then one can say, but if you want to achieve that, then the clause needs to be rewritten to make that clear. If the intention is that you want to create a pool of land that now belongs to the nation and licenses can be granted for people to access that land, then you know, so be it, and knock yourself out and try and make a success out of that. Don't have a lot of hope for that, I think, practically speaking, but the difficulties at this stage is that they try to leave it open and keep it vague so that it can mean just about anything, either the extreme example of what the EFF wants or the totally benign one. And I think one is entitled to know what it means. And they must explain that and then write it in that way so that it's clear.
Thank you.
Thank you, Annelies. Your questions are very difficult. I'm glad you're not a judge.
I'm so sorry. Thank you very much. Prof Vivian, you have the last word, and then I'm going to close.
Okay, I think Pierre's correct. He's asked very complicated questions which normally can't be answered. I don't think I can answer them either. So I think I will just endorse the approach of Adv de Waal in the current matter. Because I think what we should do is to convince everybody to take state custodianship out of the current amendment and deal with it separately. And once we know what that means, then think again about Section 25. But I don't think in its current form, it will be a disaster to go through. So, and for the reasons we've given, everything is uncertain and unclear. So you're putting into a constitution an end game when you don't have the end game. So take it out of the constitution, work out the end game, and then look back at the constitution. And I think Piers answer his question. I think I'll spend the next 5 or so years thinking about it, then I'll come back.
Thank you very much.
It's a very fundamental question, which is always asked. Look, your current situation is not working, therefore let's replace it. But we don't know whether the replacement is going to be any better. And you want to replace it because you're going to argue the current situation doesn't work. But in fact, the current situation may be working. All you have to do is get other parts of it to work. But it's a complex question.
Sounds like that's a topic for another webinar. Thank
think
you
so.
so much to the three of you. The farming community is indebted to you. We really appreciate your time, and thank you for all the participants who listened in today.
Thank you.
Bye.
Bye-bye.